What if your green card application was suddenly put on hold without any warning or explanation? This is the alarming situation now being reported by immigration attorneys and applicants across the country, as USCIS appears to have halted processing on certain categories of green card applications effective immediately. The reason this news is spreading so rapidly is because for many applicants, their green card represents years of waiting, thousands of dollars in fees, and the culmination of a long and stressful immigration journey. To have that process suddenly stopped creates not just frustration, but genuine fear about what comes next. Reports suggest that USCIS has issued internal guidance directing officers to pause adjudication on specific types of green card applications pending further review. While the agency has not released a formal public statement detailing which categories are affected, sources familiar with the situation indicate that the halt appears to involve employment-based green card applications in certain preference categories, as well as some family-based applications that require additional security vetting. To understand why this is happening, you need to understand how green card processing works and why sudden halts can occur when an individual applies for a green card. Their application goes through multiple stages of review. This includes verification of eligibility, background checks, biometrics collection, and in many cases, an in-person interview. At any point in this process, USCIS can pause an application if there are questions about eligibility, if additional evidence is needed, or if broader policy changes require updated review procedures. What appears to be different about the current situation is the scope and suddenness of the halt. Immigration attorneys report that clients who were expecting imminent approvals have instead received notices indicating that their cases are being held for additional review. Some applicants who had already completed their interviews and were waiting for final decisions have seen their cases go silent, with no updates in the system. Others have received requests for evidence that seem to go beyond what is typically required at their stage of processing. Sources indicate that this halt may be connected to broader policy reviews being conducted within DHS. The administration has emphasized its commitment to ensuring that all immigration benefits are properly vetted and that no applications are approved without thorough verification. This has led to increased scrutiny across multiple benefit categories, including green cards, naturalization, and visa extensions for employment-based green card applicants. The situation is particularly concerning. Many of these individuals are highly skilled workers who have been in the United States for years on temporary work visas. They have been waiting in backlogs that in some cases stretch for a decade or more. A sudden halt to processing could mean additional months or even years of uncertainty, during which their work authorization could expire or their employers could face difficult decisions about whether to continue sponsoring them. The impact on family-based applicants is equally significant. These are individuals seeking to reunite with spouses, parents, or children who are already United States citizens or lawful permanent residents. For families that have already been separated for extended periods, any additional delay is deeply painful. Reports suggest that some family-based cases are being held because of questions about the legitimacy of relationships or concerns about potential fraud. While USCIS has always had the authority to investigate these issues, the current environment appears to have heightened the level of scrutiny being applied at the institutional level. USCIS has faced ongoing challenges related to staffing, funding, and processing backlogs. The agency relies heavily on application fees to fund its operations, and fluctuations in application volumes can create budget pressures. Some observers have suggested that the current halt may be partially driven by resource constraints, with the agency prioritizing certain case types over others. However, this explanation does not fully account for the reports of cases being actively held rather than simply delayed in a queue for applicants. Currently caught in this halt, the situation requires careful navigation. Immigration attorneys recommend that affected individuals continue to monitor their case status through the USCIS online portal and respond promptly to any requests for evidence. It is important not to assume that a lack of updates means the case has been denied in many situations. Cases remain pending for extended periods before eventually being approved, however. Applicants should also be prepared for the possibility that additional documentation or even a second interview may be required. Those whose work authorization is tied to their pending green card application should pay close attention to their employment authorization document expiration dates. If an EAD is set to expire, applicants may need to file for a renewal to maintain their ability to work legally while the green card application remains pending. USCIS has provisions allowing for extended work authorization in some situations, but these rules can be complex and vary depending on the applicant's specific circumstances. For individuals who believe their applications have been wrongly delayed or who have experienced unusually long processing times, there may be options to seek assistance. USCIS offers a process for submitting case inquiries when processing times exceed published estimates. In some situations, applicants may also be able to seek assistance through their congressional representative's office, which can make inquiries on behalf of constituents experiencing immigration delays. Legal action through federal court is another option in extreme cases, though this is typically a last resort and requires the assistance of an experienced immigration attorney. The broader implications of this halt remain unclear. If USCIS continues to hold large numbers of applications for extended periods, it could significantly impact the flow of legal immigration to the United States. Employers who rely on foreign workers may face workforce shortages, families may remain separated for longer than anticipated, and the backlog of pending cases, which is already at historic levels, could grow even larger for now. The situation remains fluid. USCIS has not announced how long the halt will last or what criteria will be used to determine when held cases can move forward. Applicants and their attorneys are watching closely for any official announcements or policy updates. This is a developing story, and further information may emerge as more details become available about the scope and duration of this processing halt.